do. On March 2023, USCIS conducted an initial random selection of properly submitted electronic registrations for the H-1B visa cap, including beneficiaries eligible for advanced degreed exemption. But only those petitioners with selected registrations for fiscal year 2024 are eligible for the H-1B cap, and there is a 65,000 person H-1B cap, plus an extra 20,000 for people with master's degrees. And then in the beginning of April, you hear if you are selected and you file your H-1B visa. If you're not selected, then you got to figure something else out. Well, something different happened this year. On July 27th, USCIS determined that they would need to select additional H-1B visa registrations for fiscal year 2024 to get to the allocation of 65,000 H-1B visas and 20,000 additional for master's degrees. So if you were not part of the H-1B program to begin with and you did not get selected, there is a possibility that you can still be selected. It's a little unusual this year. Usually you hear by April, and if you're not selected, well, then that's the end of it. But this year they're going to be selecting some more H-1B visa applicants as of July 27th. So hopefully, if you didn't qualify for the original H-1B, you didn't get selected for the lottery, hopefully you'll get selected now, and then you'll have an opportunity to file your H-1B visa application. The Department of State's National Visa Center began issuing invitations under the Family Reunification Parole process for Colombia, El Salvador, Guatemala, and Honduras as of July 31st. On July 7th, Department of Homeland Security announced implementation of new parole processes for Colombia, El Salvador, Guatemala, and Honduras. And the parole processes are available by invitation only to beneficiaries on a waiting list with approved I-130 visa petitions who are nationals of Colombia, El Salvador, Guatemala, or Honduras. So if you have an I-130 visa petition filed for you and approved, and you are from one of those countries, you could conceivably be getting an invitation to get paroled into the United States and wait for your green cards here. And this process provides, obviously, a safe, orderly way for people from these countries to join their family members in the United States. The invitations will be mailed or emailed to your petitioner, and it will identify you, the beneficiary, who would be eligible for consideration, along with any of your family members, which could be a spouse and children under 21. So if you are a beneficiary who believes you may be eligible for this new parole process, make sure the National Visa Center has your petitioner's current contact information and mailing address. Invitations are going to be going out on a rolling basis. And if they send it to a wrong email address, they send it to a wrong mailing address, you're never going to get it, and they're not going to keep sending it over and over again. So make sure your addresses are correct there. Everywhere you look in the immigration system, it's backlog, backlog, backlog. Over 1.6 million people are stuck in the employment-based green card backlog. Over 2.3 million people have cases pending before the immigration courts. And tens of thousands of young people from Mexico and Central America are stuck in the special immigrant juvenile status backlog and forced to put their lives on hold until visas become available. Now, add to that the U visa backlog, according to data updated most recently on the USCIS website as of June 28th. The U visa was established a generation ago in the year 2000 to provide a pathway to status for victims of crimes who help in the police investigation. And if approved, U visa applicants also provide a pathway to status for certain family members, such as children and spouse. Now imagine a scenario where a person who is undocumented is the victim of a crime. Naturally, that person may be reluctant to work with law enforcement. They're scared police will say, hey, we're going to deport you. But making sure that we have good public safety in the United States takes precedence over deporting somebody who is undocumented, especially somebody who was the victim of a crime, which is why they came up with this U visa, to give people some sort of relief valve to make sure that if they are the victim of a crime, that they will report it and help the police and district attorneys prosecute the perpetrators of these crimes. Well, there have been so many crimes against undocumented immigrants in the United States, and there are over 325,000 applications pending for a U visa. That means 325,000 undocumented immigrants have been the victims of serious crimes. We're not talking about petty crimes. We're talking about serious crimes against them. And they only give 10,000 U visas a year. So that means if every person who applies for the U visa gets approved, somebody's going to wait 32 and a half years for a green card. So something has to be done about these U visa backlogs as well as all the other backlogs as well. And I get a lot of questions about COVID-19 vaccination requirements to enter the United States. So I'm going to go over them with you. The Biden administration dropped the requirement for COVID-19 testing in June 2022, but kept in place the vaccination policy for non-U.S. citizens and non-permanent resident travelers. Now, the United States has now suspended the COVID-19 vaccination requirement in connection with the end of COVID-19 public health emergency declaration. So as of May 11th, 2023, if you are a non-immigrant visa traveler coming to the United States of America, whether a student, whether a tourist, whether whatever non-immigrant visa you're on, you no longer need to prove that you have a COVID vaccination. And you will no longer be barred from coming to the United States or getting on a flight to the United States because you do not have a COVID vaccination. That is for non-immigrants, tourist visas, student visas, the H-1B visas. However, on the immigration side, COVID-19 vaccinations are still in play. Applicants applying for adjustment of status, applicants who are applying for an immigrant visa in another country must receive at least one dose of the COVID-19 vaccination. No one's going to check whether you got the second dose or not, or you got boosters or not, but you need to prove you had at least one dose in order to get approved by the medical doctor to obtain your green card via adjustment of status or via your immigrant visa processing at a U.S. consulate abroad. On Tuesday, July 25th, a federal judge struck down a stringent new asylum policy that government officials have called crucial to managing the southern border, dealing a blow to the Biden administration's strategy that has coincided with a sharp decline in illegal crossings by migrants in recent months. The rule, called the Circumvention of Lawful Pathways Rule, which has been in effect since May 12th, disqualifies most people from applying for asylum if they have crossed into the United States without either securing an appointment at an official port of entry or proving that they sought legal protection in another country along the way. Judge Spar ruled that what the CLP, which is the Circumvention of Lawful Pathways Rule, is unlawful because it undermines Congress's clear intent to allow people to apply for asylum on U.S. soil. So if the Biden administration says if you come onto U.S. soil undocumented, you can't apply for asylum, that is against the plain reading of the law. Judge Spar stayed in order for 14 days to restore a regulatory regime that has been in place for decades. This has been the law for generation after generation after generation, just recently changed under Trump and Biden continuing it. The Department of Justice has already appealed this ruling, agreeing to a request by the Biden administration to give it more time to appeal. And the Biden administration introduced this asylum rule back in May when it lifted the public health measure known as Title 42. And since then, the number of migrants apprehended at the southern border has plummeted. In June, fewer than 100,000 people were arrested, the lowest figure since February of 2021. Most of the U.S. military has restarted a program that allows green card holders to become U.S. citizens faster as soon as they enlist. Trainees can start and finish the naturalization process now during basic training. It used to be you had to be in the military for 1 year. You had to be a lawful resident for 1 year. Now you have a green card, you're in basic training, boom, you're going to become a U.S. citizen. The change comes at a time when the military is having trouble attracting recruits and retaining those already in uniform. A partnership between the Department of Defense and Department of Homeland Security allows active duty service members with green cards to become citizens during basic training. To be eligible for naturalization, trainees must pass a background check, an English and civics test, personal interview to demonstrate high moral character. You still got to go through the whole process, but it's going to be expedited and very quick. And it doesn't matter how long you've had your green card. It doesn't matter how long you're in the military. You're just going to become a U.S. citizen. Now, when applying for U.S. citizenship as a non-military civilian, the naturalization process is still going to take months or years. But through the military, it takes just weeks to become a citizen. And it's all during basic training. And while citizenship is not required to join the armed forces, it is a requirement to re-enlist in the armed forces. And without it, service members don't qualify for a security clearance. If you don't have citizenship, you can't get a security clearance, which means many military jobs are off limits. More than 135 airmen in the Air Force have become U.S. citizens during basic training just this year alone. Colonel J.P. Odell, Vice Commander for the 37 Training Wing at Lackland, helped get the initiative off the ground. He said he admires the trainees' decision to serve in a new country. Odell said, "You and I were born here. We didn't get a choice. They had a choice, and they chose to serve. Their backgrounds, education, and life experiences all contribute to making this a better force." And Odell hopes the ability to naturalize during basic training will help the military make a dent in its recruiting problem. Now, all of the service branches except the Marine Corps are naturalizing green card holders at basic training. According to the Department of Defense, about 7,000 people with green cards each year join the U.S. military. In Sonoma County, California, a rare win by non-U.S. citizen workers on non-immigrant temporary work visas with the union. Now, Moritzen Farms in Sonoma County, they're going to pay 21 of its former workers, all who are on H-1B seasonal working visas, the 6-month seasonal working visa. They're going to pay 21 employees $328,077 as part of a settlement with the California Agricultural Labor Relations Board. It's called the ALRB. Following an investigation spurred by the farm workers' complaints, the ALRB officials determined that Moritzen Farms retaliated against an entire crew of former H-2B employees because some of them organized at the end of 2021 growing season to speak out against unsafe working conditions. Now, what is so special about these workers is that they were non-immigrants from Osaka, Mexico. They were in the country on H-2 visas. And the H-2 visas allow agricultural workers to stay in the U.S. for obviously a limited period of time, for months at a time. And it was reported last year that despite promises from company leadership, none of the workers who spoke out were called back for the 2022 season. So in its complaint filed against Moritzen this past March, the ALRB determined that Moritzen did not sponsor these workers to come back and work in their fields because they tried to put a labor union together. Martin Rivera, one of the workers who spoke up against the conditions at Moritzen Farms, said, "When I got the news, I thank God it went this way because this was not easy. We were all afraid to speak up." He's currently in Osaka, Mexico, and he's working several jobs to support his wife, who's expecting their first child. Sandoval Rivera and his colleagues said they experienced verbal harassment from their supervisor, were denied shade while working in the fields on days that were hotter than 90 degrees, and did not receive breaks for lunch, except for a few occasions, all of which violates California labor regulations. 6 of the workers, including Sandoval, sought the support of labor rights groups to mediate the situation. Now, at this mediation, Vineyard manager Cameron Moritzen promised that conditions would improve and assured the workers that he would hire them again in 2022. relieving the workers of their biggest worry of not getting hired back and not getting new visas to return. But come 2022, the farm never hired them back. And since they never got hired back, they got stuck in Mexico with no work and no ability to make a living. So when the workers from Mexico realized that they could not return on their visas, they filed a claim with the ALRB, who found that Moritzen Farms retaliated against the entire team of workers, 21 workers in total from Mexico. The $328,077 settlement, which is going to benefit all 21 laborers, represents what the workers lost by missing the 2022 growing season. So congratulations to the farm workers in this case, and may this set a precedent for immigrant workers to feel able to speak up if they face workplace mistreatment or abuse. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.